Be ready. Start. Shri Arun Jaitley. I just want to make a brief comment as far as this legislation is concerned. Originally, the Benami Transaction in bracket Prohibition Act was enacted in 1988. The tenor of the provisions of that act had only 9 sections, and any person who wishes to acquire an asset or a property must do it in his own name with his money. If he acquires it in the name of somebody else, then it is deemed to be Benami property. Para. Even though two judgments of the Supreme Court came as to which is a Benami property and which is not a Benami property from 1988 till today 2016. This law has not been put into effect, and the reason why this law was not given effect was that the law provided for two significant provisions as to the fact that if there is a Benami property, Benami transactions are prohibited and the state will have the power to acquire the Benami property. Further, that the person who enters into this Benami transaction is liable to be prosecuted. There was nothing else mentioned in the Act. When this Act went to the Law Ministry thereafter, there was no machinery provided for as to how the acquisition would take place, as to what would be the terms of the acquisition. When this law was framed, it was thought that everything else would take place by virtue of rules. Probably the Law Ministry thought, and rightly so, that this could be a case of excessive delegation. There are some vital provisions in every law which have to be provided in the legislation itself, and some non operational provisions could be operationalized through the rules itself. So, the law ministry said that rules cannot be framed. So, this act had to be operationalized through rules, and the rules were never framed. Para. Thereafter, an effort was made and to begin this particular legislation. Subsequently, after this legislation was brought in, it was then redrafted in 2011 by the UPA government in the form of amendment to the 1988 bill. The reason why we want to amend the 1988 bill, the original bill has 9 sections, but a large numbers of sections were added. One proposal was that it should be repealed and a new bill should come in. But then, if we brought in a new bill, properties acquired Benami between the period of 1988 onwards would have all gone scot free. So it was considered necessary that the old law be allowed to remain and the new amendments be inserted into the old law itself. Now that bill lapsed within the lapsing of the Lok Sabha, even though it was referred to a standing committee and the report did come. Para. In 2015, a fresh amendment bill was introduced by us. The original bill has 9 sections and the amendment bill has 71 sections. The reason for incorporating the amendments in the bill is again the same, that we want the bill to be operationalized from 1988 onwards. A large number of amendments have been introduced. This bill has been referred to the Standing Committee. Stop.